Okay, we're on week 4. Today we're going to be talking, or this week we're going to be looking at something all of you have a lot of experience with, and you deal with it every day, both in your personal lives and your business lives, and that is the business entities. What are the different types of organizations? We're going to end the week by talking about agents, respondeat superior, employer-employee agency issues. Okay, for the corporations, I want to make sure that you learn the various organizational forms of business that can be used to conduct business. I want you to understand the factors to consider when you decide on forming an organization, the tax liability, personal liability, both tort and contract, and management control of the various types of legal entities. And I want you to appreciate the complexity of making a decision on the organizational form. In fact, we'll be talking about how do you make a decision. What type of legal entity do you want to do to start a business? Or if someone's asking you, what would you recommend to them? One of the first things to realize is that the separate entity theory, that is that some businesses, in fact, all businesses other than sole proprietorships, are a separate legal entity. The business can own and hold property in its own right. The entity can sue and be sued, but in some cases, so may its owners. That depends on if it's a partnership, for example, if it's a general partnership. A sole proprietorship is not a separate legal entity, even if you open up two separate bank accounts, one in your name and one in the name of the business that you're running as a sole proprietorship. See Lambert but FSLIC on Moodle to see what happens when somebody thought they did. It cost them about $100,000. Okay, forms of business. What we're going to be talking about are 4 different forms of businesses: sole proprietorships, partnerships, corporations, and LLCs. I'm sure all of you have heard of these entities before. Partnerships have 2 subcategories. There are general partnerships and limited partnerships. And a corporation has 3 subsections, or 3 different types of corporations: a C Corp, or also called a regular corporation, a subchapter S or a sub-S corporation that has certain tax consequences we'll talk about, and a non-profit corporation. We're going to just talk about those real quick this time, and then week 6 we go into great detail on what constitutes a non-profit corporation. And then the LLCs. Okay, what are the things you want to consider when you are selecting an organizational form? Well, first and foremost, most people are very concerned about the owner liability. Who's going to be liable for torts and contracts? The second most important category is taxation. As we will see, corporations, at least some types of corporations, the C Corp and the regular Corp, are double taxed. You've probably heard a lot about that, especially recently, as we've been looking at some of the presidential candidates' tax status and Warren Buffett's low tax rate compared to his secretary. Well, we're going to see what it means when Warren Buffett owns a corporation that is doubly taxed. Partnerships, LLCs, sole proprietorships are not double taxed. And the cost of creation, you can spend a lot of money going through a lot of lawyers getting very, very creative. I know I did it once, spent thousands of dollars to create an organization that had operations in the U.S. and in Mexico. There was a couple of Mexican corporations, a couple of U.S. corporations, one buying and selling to the other. Tremendously expensive, and for me at that time it was a waste of money because I didn't need that sophisticated of a structure. So you have to be aware of the cost of creation. And since it's your company and you're forming it, or at least that of somebody may be looking for your advice, you certainly want to let them know what's going to happen to their control of that entity, that company that they started. Different structures will have different types of management control. And finally, what is the continuity and stability issues of the legal entity? If a owner dies, does that end the entity or does it pass on? Okay, the first one we're going to look at, sole proprietorships. Easiest, cheapest to find, easy to create. You have to file a DBA. What's a DBA? Doing business as. It's nothing more than putting a notice in a newspaper saying, I'm now doing business as H&H Operations. Used to be in that it is owned personally and solely by me. How many people are in ownership of a sole proprietorship? One, if you have two people, you have a partnership. Sole proprietorships are owned by an individual. It has a continuity of management. The person that starts it is the owner. They say they can do what they want. They have no fiduciary duty to anyone else. They can hire their kids. It's up to them. Liability, the owner is personally liable for everything that happens in that company. Does that mean that the owner cannot hire employees? Of course they can. Sole proprietorships hire employees all the time. You can start a lawn mowing company and hire people to do the lawns, and hire secretaries and tax people, anything you want. The difference is that the owner is the one that's solely liable, not the lawn mowing company. The lawn mowing company is the owner, and vice versa. Allows for flexible tax planning. You can hire your children and your relatives so long as they get reasonable salaries, only from tax avoidance, but you can pay them anything you want. There's no fiduciary duty to anyone else. The owner is the principal and the owner. We're talking about fiduciary duty under agency later in the week. So sole proprietor bears the entire risk of loss. He or she will lose everything that they put into it, their capital and their house, everything else, if there's a tort claim that is not insured. Sole proprietor has unlimited personal liability. General partners do also, but this is one of the biggest drawbacks of sole proprietors. It is the same thing as if the person was running it in their name, because that's what they're doing. Finally, the business dissolves with the death of the owner, and it's also very difficult to get financing for sole proprietorships. Okay, moving on to more common type of business entities, partnerships. A partnership is two or more people that form a business to run it for a profit. They have a common business interest. They share profits and losses. Unless the partnership agreement states otherwise, the profits and losses are split proportionately to the ownership interest. But as we will see, individual partnerships can designate a different profit and loss formula. Creation, again, is very simple. You draw up a partnership agreement. You say what people are going to do. In Oklahoma, they'd like you to file a document showing that the partnership has been formed. Under the Uniform Partnership Act, it is a legal entity, as we talked about at the beginning. The partnership can own and hold property, can sue and be sued, but the partnership itself is not taxed. Again, the partnership is not taxed. Tax is passed on to the partners. There is no tax liability by a partnership, either limited or general. You have express partnerships. You can have an implied partnership based on the conduct of the parties. There's a case in the book on Volan v. Sweet where the owner gave a person a commission based on percentage of sales, and the court held that that was an implied partnership. So be careful when you're giving commissions like that. And you can file a certificate of partnership. The WWW-SOS, which is Secretary of State, is on the Moodle site, will show you how you can file that. The partnership is either general or limited, is not taxed for income tax. Again, I've stressed that because this is one of the most important things on partnerships. The taxes are passed through. There's no double tax as there is in a corporation, which we'll look at in a few minutes. Partners split the income. Partnership A has $100 of income. Partner A gets $50 income. Partner B gets $50 of income. Partner A is in a 20% tax bracket. She pays $10 tax. Partner B is in a $50 tax bracket, or a $50 income, and she's in a 30% tax bracket. She pays $15 in tax. The partnership does not owe any taxes. The individuals do. Okay, rights of a general partner. Now we're talking one specific type of a partnership. It's a general partnership, a GP. General partners get one vote. It's not based on their capital contributions. The right to share in profits and losses, if it's not set out in the partnership agreements, then the profits are split equally among the partners. However, you can do a partnership and have one partner gets 60% and another gets 40% if both partners agree to it and include that in the partnership agreement. But if it's not stated, then it's split proportionally to the number of general partners. Partners have a right to get paid. If they're doing work, they can get a salary for the work they're doing with the partnership. They have a right of indemnification. We're going to see that every general partner is liable for all of the torts and all of the contract liabilities of the general partnership, even though it should be split among the other general partners. Well, if a partner has to pay more than their pro rata share, then it can be split. They have the right of indemnity so that the other partners will have to pay them the extra money that they paid out to the claimant. They get the right to the return of their capital and a right to information. Duties of partners. Partners owe a duty of loyalty to the other partners. They cannot usurp a company's opportunity. You cannot see a good deal, good piece of real estate and buy it for yourself if you're a general partner, and that is the business of the general partnership. They also must use reasonable business judgment, and they have a duty to inform of any pertinent information or any undisclosed profits that they may be making. Even if they're selling paper to a partnership and they have an interest, an ownership interest in the office supply company doing it, it may be lower than they could get it someplace else, and may be selling it at a low price. Doesn't make any difference. It has to be disclosed that he's making an additional profit. This is called a fiduciary duty. We're going to talk about that under agency. Partnerships act through their partners, their agencies. General partners are jointly and severally liable for contracts and debts of the partnership. See Kemmler Memorial Foundation v. Mitchell. You'll find out that a partner is jointly and severally liable for everything that the partnership does. They can get the money back from other partners, but only the claimant or the plaintiff needs only sue one of the general partners. Tort liability of third parties. A partnership is liable for all the tortious acts of any of the agents of that general partnership, including other general partners. All partners are jointly and severally liable, which means that a plaintiff may only sue one of the general partners if they want. Once a new partner is admitted, they are not liable for previous obligations. However, see Mosley v. Commercial State Bank, where the existing partners almost out of deceit were able to pass a obligation on to a new partner, and that was almost with the collusion of the bank. Nonetheless, the bank held Mosley completely liable for the loan because he was a general partner and the loan was renegotiated. So he got 6% of the income and 100% of the losses. Was he completely out the $303,000? What could he do? I hope you answered that he could sue the other general partners, and they can under the indemnity clause. Process of liquidating a partnership is assets are distributed first to any outside claimants, to creditors, creditor partners, capital contributions, and then profit split according to the partnership. So A contributes $40,000, B contributes $60,000. B has a loan of $10,000. There's $80,000 of income. How is it split? Stop and think about it. Okay, it's split $40,000 to each because the partnership agreement didn't specify otherwise, and if it doesn't specify, then it is split proportionally. Then, on dissolving, they had $50,000 in debts to the vendors, with $200,000 from sale of assets. Creditors got $50,000. B, as a creditor, got $10,000. A and B each got their capital back, $40,000 and $60,000. The balance of $40,000 was split $20,000 each because that was the profit split. It goes outside creditors, inside creditors, return of capital, and then income split. A limited partnership is very similar, except that the partners are limited and they have no liability. They get a proportionate share of their tax income, but the general rule is that limited partners are not liable. The exceptions is if it's defective formation, it's really a GP, if there's a personal guarantee, or if they participate in management. But see Frigidaire Sales for a way to get around that. Okay, different activities that are approved. You can look at these, look this over. It's on the PowerPoint. These are things that LPs can do. They have to be very careful because if they don't, if they are considered active in day-to-day management, they will be considered a general partner and held personally liable for all the obligations of the partnership. Okay, that was quick and dirty. We'll finish up on Part B on corporations.